Mr. Wagner, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges, sir?
Yes, I understand.
All right. The docket before you, Your Honor, is 2019-846DS in the matter of Ms. Kelly Bridges versus Mr. Derek Wagner, with Mr. Wagner being the payer. This is an adjourned enforcement hearing. It was adjourned to allow him to be represented by court-appointed attorney as requested. It was originally, prior to that adjournment, a bench warrant hearing for his failure to appear at a referee hearing on June 13th of 2022. The order being enforced today is the modified uniform child support order dated January 13th of 2020, which states that his current child support is $109. After servicing and processing fees, brings it to $112.50. His last payment was $148.28 on September 3rd of 2021 via unemployment. He has been show cause 3 times with 1 bench warrant and 1 finding of contempt. The previous 6 months at $112.50, he should have paid $675, and he has paid none.
Because he's a bum.
Please take a moment to calm yourself. We understand that you strongly dislike him, and that feeling is clear. However, the enforcement officer is doing an excellent job calmly presenting the facts that already support your case. By contrast, the repeated interruptions and disrespectful comments are hurting your position, not helping it. They shift attention away from the evidence and toward your behavior instead. Staying quiet and composed would serve you far better right now. Let the facts speak for themselves. When professionals are already building a strong case on your behalf, the smartest move is to allow the process to continue without unnecessary disruptions.
February 28th of 2023, his total arrearages are $4,747.94. There have been no previous jail sentences with that previous contempt hearing. Mr. Wagner was booked in on March 3rd in the Calhoun County Jail on separate charges. When he was booked in on our warrant, he was in jail from February 16th to February 23rd.
Okay, do you have any questions for Ms. Wills?
Yes. Ms. Wills, has he been in jail since February 16th?
No, so he was in jail February 16th to February 23rd. He bonded out on the 23rd, and then he was booked back into jail on March 3rd. And he's been there since March 3rd on separate charges that are not FOC related.
And does he qualify for the LEAP program?
Nope.
No, so with Mr. Wagner, let me make sure that we have his correct address on file. The previous address, he does qualify for LEAP. However, due to, us not being able to get in contact with him and having the bench warrant for so long, he did not qualify. He does now, as long as he doesn't have any other warrants in the state of Michigan.
Okay, thank you. No further questions.
Okay. Any proofs, Mr. Secretary?
Yes, I'd call Mr. Wagner.
Okay, go ahead.
All right, Mr. Wagner, can you hear me?
Yes.
You heard the testimony of Ms. Wills, is that correct?
Yes.
Is there anything that you disagreed with?
No, sir.
Okay. So you were booked in, looks like February 16th, and then you bonded out on February 23rd by posting a $100 bond. Is that correct?
Correct.
Are you willing to put that bond amount towards your child support arrearages?
Absolutely.
He needs to pay more than $100.
You need to stop speaking right now, because interrupting the court in a disrespectful way can lead to serious consequences. It can result in fines, penalties, or wasted time, things that will only make your situation harder. Those are resources you clearly need to focus on caring for your child, not losing over avoidable behavior. The smartest choice here is to remain quiet until you are officially given the chance to speak. Allow the court to do its job properly. Showing patience and self-control will protect your interests and help ensure the process moves forward fairly and smoothly.
Okay, hold on a second. Ms. Bridges, we're taking testimony from Mr. Wagner, not from you at this time. You'll have an opportunity to speak after that, so please don't interrupt.
Okay. All right. Ms. Wills testified that you're being held on other criminal charges in the jail. Is that correct?
Yes, sir.
Do you have a hearing date or a release date for those other charges?
I have a release date on the 8th.
On April 8th,
Yes, sir.
you're expected to be released.
Yes.
Okay. Prior to February 16th of 2023, were you employed?
No.
Lie.
Hold on a
Okay.
second. Just hold on. Ms. Bridges, was I unclear about not speaking or interrupting? Ma'am?
So what? Y'all can shake a piece of shit motherfucking hand and say
Hey,
congratulations.
ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
Just proceed to the fucking court hearing and shut up.
At this point, the way you're speaking is completely inappropriate for a courtroom setting. Your language alone has already given the judge more than enough direct reason to hold you in contempt of court. What makes this situation even more surprising is that Judge Kirkman is normally very strict about courtroom behavior. He rarely shows this level of patience when someone repeatedly ignores the rules and shows open disrespect. Yet despite all of that, he is still offering her another chance to regain control, adjust her behavior, and show basic respect for the court. That extra opportunity is generous, and it may be the last one she gets if the behavior continues.
Ma'am? One more outburst or one more vulgarity and you will be going to jail. You understand?
Good luck.
What, ma'am?
I said good luck. Finish court.
That man issues arrest warrants as part of his daily job, so this situation is not something to take lightly. He makes serious decisions like this regularly and does not rely on chance or emotion. Hoping for good luck here is unrealistic because the process is based on rules, evidence, and conduct. When someone ignores courtroom standards, the outcome is usually very predictable. The smartest approach is to understand who you are dealing with and act accordingly. Respecting the court is not optional, and assuming leniency is a risky mistake.
Ms. Bridges, you can ask Mr. Wagner any questions pertaining to the issue before the court, which is his non-payment of child support. Do you have any questions?
I already know why his non-payment of child support is, why he's had a job the whole time working for Larson's Construction, making $26 an hour underneath the table for months now.
Okay, ma'am, this is your time to ask him. This is your time to ask him questions, not for you to give a statement at this point. So if you have any questions for him, ask those.
Okay, Derek, seeing you had money to buy alcohol, why were you not paying your child support?
I was terminated because you had contacted FOC before I had a chance to be placed on payroll, so I was terminated.
That's not my fault. You know you're supposed to pay child support. Pay your shit. Be a man. Instead of a bum drunk.
She may come across as overly emotional, but to be fair, she does raise a valid point. Even if her delivery isn't ideal, the concern she's expressing shouldn't be ignored completely. That said, both individuals seem to be feeding into the conflict rather than resolving it. Their reactions mirror each other in a way that only escalates the situation. From the outside, it almost appears that their similar behavior is what keeps the issue going. If either one showed maturity and restraint, the situation could look very different.
Court will make the following finding in this matter. In this case, Mr. Wagner has a minimal support obligation of $148.50 per month, including his arrearage repayment in this matter. That, in fact, over the last year, he has, as he stated, he's worked approximately 2.5 months during that time, making $200 per week. On each of those weeks, that he acknowledges that he simply failed to pay, and there's no excuse for not doing so. In addition to that, he did have odd jobs He stated that he has been hindered somewhat because he has not had an ID or a birth certificate, etc., to acquire employment, but he has not stated any effort he's made to acquire that. Likewise with the GED, other than that he's had no money to do that. The court will find that he has had the present and the ability to pay, that he's failed or refused to pay, and therefore he is in contempt of court. Anything before sentencing, Mr. Sackrader?
Yes, thank you, Your Honor. My client testified that he will be on probation upon his release and his other criminal matters, and he will be.
Karen, everyone on this Zoom call is expected to behave exactly as if they were physically present in the courtroom. The rules and standards are the same, even though the setting is virtual. So ask yourself this simple question. Would you light up and smoke inside a courtroom? Of course not. That behavior would never be allowed in person. Because of that, it's also not acceptable during a Zoom hearing. Treat the virtual court with the same level of respect and professionalism as a real one, and follow the rules just as you would if the judge were sitting right in front of you.
Looking for employment to satisfy this obligation, we would ask that any jail sentence be 31 days or less, with credit for 7 days already served in this matter. We would request a purge amount in the amount of $400. Thank you, Your Honor.
Thank you. Well, in this matter, Mr. Wagner, I could sentence you up to 45 days. I'm not going to do that only because it is your first time that you would have any jail time, even though you did have a prior contempt. There was no jail time at that point. What I'm going to do is I am going to sentence you to 21 days in jail with credit for 7 days served. And I'm going to put a purge amount in place of the amount of $500. If you're able to pay the purge amount, then you would not have to serve the balance of your jail sentence. Do you have any questions, sir?
No, Your Honor.
Okay. Court will end this matter at 11 a.m. You're free to go. Have a good day.
That's bullshit. You guys shake his hand and tell him congratulations.
Ma'am, the case is done. We don't need to hear anything else from you.
Fuck you. Bye.
That's definitely not how I would have handled that situation. I understand emotions can run high, but there are limits to what makes sense in a courtroom setting. I also value my freedom far too much to act in a way that could cause serious trouble. Speaking carelessly or challenging a judge directly is never a smart move. When you're standing before someone with real authority, the safest and smartest approach is to stay respectful, measured, and aware of the consequences. A little self-control can prevent a lot of unnecessary problems.
Hold on, ma'am. The court is going to hold Ms. Bridges in contempt of court based upon the last outburst and the last vulgarity. Ms. Wills, do you have Ms. Bridges' phone number? Can you contact her and get her back?
Yes. Let me just go ahead. If you allow me, would you like me to go off record while I call her right now to get her back on the Zoom?
No, go ahead. We'll just hold on and put her on.
Okay. Hi, Ms. Bridges. This is your enforcement officer. Judge Kirkham was wondering if you could please log back on to Zoom to speak with him. If you could please log back on, Judge was requesting that. Okay, just log right back onto the Zoom room and they'll let you in. She hung up on me. So I'm unsure if she will log back in or not.
Let me see. This may be her.
Okay. Yes, that's her.
Oh yes, that's definitely her. I can recognize that look instantly, the expression of someone who's moments away from making a very bad decision. It's the kind of face that says trouble is coming, whether she realizes it or not. You can almost tell she's about to follow the same path as her child's father, simply by refusing to slow down and think. Instead of learning from what's already happening, she seems ready to repeat the same mistakes. At this point, the situation feels tense and predictable. When people ignore clear warnings and keep pushing limits, the outcome rarely ends well, even if they think it will be entertaining to watch.
Ms. Bridges, I had warned you multiple times about your outbursts and the vulgarity, and apparently that did not have any impact. What the court is going to do based upon the last outburst, ma'am, the court Is she muted? Are you muted, ma'am? You can unmute yourself. We can't hear you.
You don't want to listen to anything I say. You just want to shake this motherfucker's hand and tell him
Ma'am,
congratulations. Let's be a
Ma'am,
piece
the
of
court
shit
is holding you in contempt of court. I'm sentencing
You
you
ain't
to
holding
3
me to
days,
shit, bitch. Fuck off.
3 days in jail, ma'am. You will be sentenced to 3 days in jail. You will have to appear on, we'll have her appear on March 17, 2023, no later than 4:00 p.m. to serve her 3 days in jail.
Alright everyone, that wraps up the video. This all just happened a few days ago. So if anything new develops or there are updates with this situation, I'll be sure to share them with you. If you enjoyed the video, give it a like. If not, feel free to leave a dislike. But either way, make sure to leave a comment and let me know your thoughts. Don't forget to subscribe and turn on notifications so you won't miss any of my future content.